Our second panel of the day is going to focus on the relationship between the executive branch and the legislative branch. Our moderator for this panel is the Honorable Judge Jennifer Walker Elrod, who sits on the United States Court of Appeals for the Fifth Circuit. Judge Elrod is a graduate of Baylor University and here of Harvard Law School. She served previously as a state judge in Harris County, Texas, and she also clerked in the Southern District of Texas for Judge Sim Lake. Joining her on the panel today, from closest to me to furthest, we have Professor Jed Handelsman Shugerman, professor of law at Boston University Law School. Congratulations or condolences on that promotion or demotion, depending how you look at it. He taught previously at Fordham University Law School and here at Harvard Law School. He's a legal historian who focuses on structural constitutionalism. He is a three-time graduate of Yale, for which we additionally offer condolences, earning a BA, a JD, and a PhD there, and he's currently writing a book titled A Faithful President, The Founders versus the Originalists. We also on the panel have Professor Julian Davis Mortenson, the James Phillipp Professor of Law at the University of Michigan Law School. Professor Mortenson is cheering for the University of Michigan, I see. Professor Mortenson is an expert of constitutional law and international law. He also writes in the area of administrative law, where his article last night on his article on the non-delegation doctrine was mentioned last night. He's also working on a long-awaited book on executive power. Professor Mortenson is a graduate of Harvard College and of Stanford Law School. He clerked for Judge J. Harvey Wilkinson on the Fourth Circuit and for Justice David Souter. Also on the panel today, filling in for Professor Mascott, who wasn't able to join us, is Ellie Nachmany. Ellie is a 2022 graduate of Harvard Law School and also of NYU. There's cheering for Harvard Law School, apparently. Ellie recently completed a clerkship for Judge Stephen Menashe, and he has various forthcoming and recent articles, including most recently in the Wake Forest Law Review. And last but not least, we have Professor Chris Walker, who is a professor of law also at the University of Michigan, although he recently came from what I understand has to be accentuated as the Ohio State University. Professor Walker teaches and writes on administrative law, on civil procedure, on federal courts, and he is a graduate of BYU, the Harvard Kennedy School, and Stanford Law School. He clerked for Judge Alex Kaczynski on the United States Court of Appeals for the Ninth Circuit, as well as for Justice Anthony Kennedy. So with that, I'm going to turn things over to Judge Elrod. Once again, we will take questions partway through the panel, and you can once again raise your hand, and a microphone will be brought to you, and we'll go from there. But Judge Elrod, over to you.
Thank you so much, Ben. You know, it's really wonderful to be here today. I have to say, though, this room makes me nervous. I have two memories of this room. One of them being here when I was in law school here at this school, and we were in the Ames Moot Court Finals. It was 100 years ago, so the room was configured a little differently than it is today. And alas, unlike my future incoming clerk, Brandon Sharp, who's here with his family today, who won the Ames Moot Court Finals, we did not prevail in this room. And Justice Souter was presiding that day. But Judge Pat Higginbotham was also on the panel, and he ruled for my team. He was a split 2-1. I think it may have been Judge Taha, or she may have been in the semis as the third. But anyway, and so I'm not bitter or anything. But my second memory in this room, though, was coming back to judge the Ames Moot Court Finals as a judge with Justice Sotomayor a few years ago, and it's better to be on this side of the bench than out there when you're in the Ames contest. But the funny thing about it was I am the successor on the bench to Judge Pat Higginbotham. So I want to let all of you students know, compete in moot court. Even if you lose, you can replace one of the judges one day. I would like to thank the student leaders who have organized this event for bringing us together. Ben Ponce, Ben Rolsma, Ben Richardson, and many others have been very involved. And I love your pink Fed sock swag this year. So I just think you've done a fabulous job. And I was a member of the Fed sock chapter here, and it was a very small group, as I recall. And I never dreamed that there would be students from all over the country gathering to hear these interesting scholars talk about the Constitution that we all know and love, and what a tribute it is to the scholars who come, to those who have arranged these events, and to you students who are devoting your spring break time, many of you, to saying, I'm going to go and learn more about what makes our government work. So bravo to all of you. As Justice Scalia has said, and as others have mentioned, I believe, during this time we've had together, it is the structure of our Constitution and our government that protects our freedoms. And I'm very pleased that this conference is devoted to the separation of powers. I'm very thankful to these wonderful professors from all sorts of who have different philosophies and prodigious writing on the subject to be here with us today. We want to talk about these issues in a scholarly manner, but we also want to know, why does it matter? And I hope that you will keep both of those things in mind. And I believe, Professor Shugerman, we're going to start with your historical take on this.
Great. Well, thanks very much, Judge Elrod. Let me first say thank you to the organizers, to the many Bens around here. And I gave to some of the Bens a handout that if they've already distributed it, just if it goes around, it's speaking of, I guess just ideas of distributive justice. I only made 50 copies, which is maybe the sense of how many people will show up to listen to me. And also there's an overflow room. So if you can share the copy, and I also forgot to hold on to a couple copies. So if the distributors can bring at least 2 or 3 up here in the front, I'd appreciate it. I don't know if anyone saw the Bill Ackman theory of names in the Bill Ackman, people around here, I imagine, have heard of Bill Ackman, right? So his theory is his name, Bill Ackman, must have been fated him to become an activist. Okay, let's set that whole thing aside. But I just note the name Ben comes from the Hebrew Binyamin, child of my right hand. So I don't know, is that kind of fated to be a member of the Federal Society, or is this overdetermined by parents who might name their children that way? I also, in addition to thank you, I also have to say a sorry, not sorry. This is now my 3rd Federal Society event this year, as well as a Cato. I wrote something for Cato and was at a Cato conference, and also participated with the Pacific Legal Foundation as adjacent organizations. And I think part of that is, maybe a lot of that was because I wrote a brief in Biden versus Nebraska on the Nebraska side. So the sorry, not sorry is, this is the National Student Convention. So for those of you with student debt, sorry, but also not sorry, because the court got it right. I'm not going to speak about that chiefly, but in the conversation, we want to make sure there's enough time for discussion and Q&A. I'm happy to talk about a defense of the major question doctrine from the left. So I have actually never voted for a Republican in my entire life. Sort of like how Justice Kagan came before the Federal Society and said, just to be clear, you are not my people, but then finished the speech by saying, I love the Federal Society, and got a standing ovation. So of course, I'd like that standing ovation here too. But I will say that as the year goes on, I have to say increasingly, I think maybe the Federal Society, despite my party affiliation, I think you may be my people. So thank you for your commitment to free speech on campus and to debate, which is part of being here. This also has led me to kind of go on in the November lawyers convention. I was on a panel with Judge Oldham. Now I'm on a panel here with Judge Elrod. So I think I'm doing a Jarkissi tour. And I agree. Let me just say what I'm happy to talk about, maybe further in further detail, is I agree with one part of the Jarkissi opinion, and it's more about the Seventh Amendment.
1 out of 3 isn't bad.
What's that? 1 out of 3. And in terms of the law, all you need is 1 out of 3 to have and it turns out, I think we may talk about this, it's clear that the Supreme Court is going to follow that Seventh Amendment path in Jarkissi. But let me say, first, I'm now one of the BU Federal Society co-advisors along with Gary Lawson. Where is Gary? I just want to acknowledge Gary has been an amazing colleague at BU for many years. We're going to miss him. He's heading to the University of Florida. I just want to thank Gary for his intellectual open-mindedness, and he's been people to a member of faculty by faculty. People have just given him credit for being such a teacher and mentor at BU, and we'll miss him. So thank you, Gary, for everything you've done. Is Michael McConnell here? I just want to thank Michael McConnell for also someone who's also been engaged with intellectual diversity. Part of the story here, too, is as I was working on this project on the Unitary Executive, out of the blue, Michael McConnell reached out and said, would you co-run a conference on the history of presidential power? And the point there was to bring together the academics who are presenting lots of history on opposite sides to engage in dialogue. And it was a great example of that as dialogue. So, and finally, I want to acknowledge, years ago I won the Harvard Law School Federal Society Charles Freed Prize, a teaching prize. Just want to acknowledge Charles Freed's passing this year. So another committed mentor and his service. So what I really want to pivot to is the big picture. The handout that you have is way too, I'm not going to go through that handout in any detail.
He's going to call on you.
Yeah, that's right. Okay. I'm going to start cold calling. If you don't have the handout, it's also on my blog, Sugar Blog, spelled my unusual way, Sugar Blog, Shuger, and it's also on my Twitter feed in a thread, so you can find it there if you'd like to follow up and track it that way. What I'd really like to talk about is in a bigger picture way, 3 different areas, and I'll try and do this concisely. One is that I'm an originalist. I used to describe myself as a progressive originalist, and then highlighting Balkan's living originalism. And then I said, I'm just an originalist, full stop. That's what I said at the November National Lawyers Convention. But I'd like to at least suggest to flesh out an idea of originalism that needs to get developed as it is a method that, and I come here to say, there is a methodological crisis among originalists right now. And it's been deepening for a long time. But part of it is that it was a reactive, I don't mean reactive like reactionary. I think originalism was developing as a critique of judicial activism, and then suddenly originalism became judicial activism. And when you're out of power, it's easier to make critiques and write dissents. When you're in power and the originalists are in power, then you actually have to start being clear about how you're using that power. So I'm going to, first of all, suggest a theory of lexical originalism. I'm sort of borrowing from Caleb Nelson and other scholars like Adam Samaha on lexical statutory interpretation. So I'll say a word about that. Then in the handout, I want to give an overview, and I think Julian and I are agree about some of this, but there are some follow-ups about the history of separation of powers. And then I want to just touch on the unitary executive theory as a site of serious questions of methodological, there's a methodological crisis as the removal cases keep progressing. So just briefly, what is lexical originalism? So I'm an originalist because I think text and context are the basis of law, and when text and context are clear, that's the end of the story, right? There aren't other methods, or maybe I can at least note that Scalia called himself a faint-hearted originalist, and in unusual or extraordinary cases, but sometimes other factors can come into play. But if text and context are clear, that's the end of the story. The problem, I think, is that the burden of what it means to be clear has to go through several questions. One, every time a historical claim is made about X, when a historian posits X, that historian bears the burden of proof. So every time there's an originalist claim, that claim about history bears a first-level burden. But when it comes to original public meaning, I actually think that's at least an extra burden, because those sources then have to establish not only about a certain set of actors thinking something, but that in originalism today, I sometimes call it originalism 3.0, the extension from those documents to establish original public meaning of the median ratifier is a very difficult leap. And so there has to be such a degree of clarity from those sources that one could extrapolate original public meaning. So that's a double burden. And then based on the judge's role, there can be a third burden. And that third burden is, how is that originalist argument being deployed? Is it being used to overturn statutes? Is it being used to overturn precedents? And then that raises an originalist question about what is the original meaning of judicial power. And I'll say something about that in a minute, but we start to see an originalist irony, because the original public meaning of judicial power was limited. Don't get me wrong, judicial review is based on original public meaning, but it was also framed as repugnancy. So Chief Justice Marshall talked about the importance of finding repugnancy. That's a high threshold. So in order for a judge to be an originalist, they also have to be cautious or circumspect about how they use that power and how originalists make those arguments. And I think that's a third burden in cases of overturning precedents and statutes. And that's why I'm suggesting lexical originalism, because it's an ordering of resources. So let me turn to the handout on separation of powers. And just note that I want to highlight this at the top here, which is that the separation, obviously everyone here knows there's no separation of powers clause. But one thing, the research I've been doing, I'm sorry, that's late breaking news. But it's important to, some of the history that Julian's been doing amazing historical research on the history of executive power. Some of the research I've been doing, I've been surprised to find, it's well known among historians that the separation of powers, the notion of powers in England was, first of all, started as separation of estates, and England had mixed government or balanced government, not a separation. England's system, as Blackstone talked about and as Montesquieu described, was more of a mixed system of overlapping powers that creates a background to checks and balances. What I've been doing research about is to figure out at what time did the judicial power emerge. And it becomes increasingly clear that the original separation lasted, that was legislative versus executive. It wasn't a tripartite, it was a bipartite separation. So then what emerges is Article 3, and the research I've done in dictionaries and treatises from the 18th century indicates that judicial power did not emerge as a category, more or less, until the Americans invented it, right? It might surprise you about Montesquieu. I'm happy to take questions about it. There's very little historical evidence that judicial power was a thing until Article 3. So that not only tells us that judicial power was new, novel, and underdetermined, that also tells us that the notions of executive power were underdetermined. And one point that comes out of that is that judges were executive officials, and that means that in England, judges were unremovable executive officers. Now, there's a lot more that I can say about that, and the handout shows you that I would like to circle back to this. But I just want to note that when we're talking about the separation of powers, there's a challenge for originalists when it comes to making arguments about clarity of meaning. If executive power was still being redefined by the Americans, and if judicial power was a novel concept, these are some of the reasons why I think it's better in jarcossy to rely on the Seventh Amendment text on the bottom of the page 2 of this handout than the idea that judicial power was a worked out concrete idea with a lot of historical basis for clear original public meaning. I'll pause there. Happy to circle back to other issues today.
Professor Mortenson.
Thank you very much. I'm delighted to be here, especially great to see my Michigan FedSoc people here. Love you guys, and pleased to meet everyone else as well. The thought for me to start off was basically to do less of a, I'll be argumentative later, I promise, but less of an argumentative presentation and more of an overview a sketch of a couple of the doctrines that are particularly in play right now along the axis that this panel is focused on, legislative, executive, and specifically to talk a little bit about the Chevron doctrine and the major question doctrine, neither of which I particularly specialize in, but I read things and I teach leg reg, so I can say a few things about it that might be helpful to set a starting point for us as we talk about where those go, where they come from, where they ought to be. So Chevron first. The basic theory behind Chevron, theory of judicial deference, is that, as I think about it, is that there's a lot of provisions in the legislative code that are technically law in the sense that they are a word in a statute and therefore are law, but also partake very significantly of fact. So standards like hazardous to health, or what's a diagnosis, or how do we know if somebody's on a salary basis for real, or what's a drug? And because of that, and because of certain beliefs about the best way to structure rule-grounded governance, where there are really hard expertise-oriented questions of law fact that are operative in deciding what the government's going to do, the Chevron doctrine doesn't really create, but sort of consolidates that instinct. And I think around two pretty important, and at least for me, highly sympathetic, or appealing, I should say, principles. The idea of Chevron is, one, judges, it says, should interpret statutes when agencies have spoken on them, it says, as though, or in light of the assumption that sometimes Congress thinks that agencies can do a better job of figuring out the right answer to what these questions is. Like literally will do a better job more of the time because of their background across a subject matter domain and their expertise with a really complicated statute over time. So Chevron says, it frames it, I think this is crucial to understand, and I didn't really think about the connection until just now because we're talking about delegation. But Chevron says the underlying justification for Chevron is a delegation justification, right? You have explicit delegations where the agency is told it can it can promulgate rules around some kind of standard. But the idea of Chevron is that there can be, and it says this explicitly, implicit delegations too. So the fact of an ambiguous fact law word existing in a statute, at least sometimes the idea is an indication of an implicit delegation, a political delegation to the agency to construct it. Sometimes, Chevron says, the legislative delegation to an agency on a particular question is implicit rather than explicit. How do we know that? When the word is open-textured, when it's susceptible of various meanings, right? That's one instinct, is that Congress literally means for agencies to work through the meaning of a term that codes as law, but that nonetheless is open-textured and kind of law fact. The other ground that I'm just channeling Chevron directly here as I read it, is that there is, as we all know and always has been, deep roots in the common law tradition and what it means to make versus discover law. There is, in fact, from any serious legal realist perspective, a pretty thin distinction, at least sometimes, between making policy and making law. Yes, there's opposite ends of a spectrum. Yes, the fact that I have hair does not mean that it could be complicated to decide when I'm officially balding, right? Like, spectrum analysis can be tricky, but nonetheless, at the margins, and maybe more than at the margins, Chevron says, if this choice to interpret a statute represents a reasonable accommodation of conflicting policies that were committed to the agency's care by the statute, the delegation idea, here's some policies, here's a word that tries to encapsulate those policies, run with it, agency, is the thought. We should not disturb it unless it appears from the statute or its legislative history that the accommodation is not one that Congress would have sanctioned, right? That's basically not a clear statement rule exactly, but a demand for like a significant threshold to be overcome, showing a wrongness, or not even wrongness exactly, yes, wrongness, but going beyond the expected boundsness of Congress. So that's Chevron, and I think of it as, in some ways, and this is maybe a strange CF, but it shows where I spend my days, as being similar to some of the logic around how habeas review in 17th and 18th century England was done, which is that the degree of skepticism that you offer in evaluating a habeas claim turns to a substantial extent on the quality of procedures that were underlying the detention. So like if it was a criminal proceeding, habeas basically could only challenge jurisdictionally. I'm not gonna get into the whole thing. But right, like basically if you have criminal trial level qualities, you get super low level, not low level, but super thin habeas review. If you're just thrown into the tower, we're gonna look at all the evidence and decide whether or not on the substance you should be there, right? And that's a function, at least in part, of how good the procedures are that produce the decision. And guess what? Chevron reflects that, at least once we explicitly recognize the idea of a, step zero, slotting, sometimes we do it, sometimes we don't. And it cashes out basically as, if you use really robust internal procedures, and they can be done in different ways, right? Rulemaking, formal adjudication. Then we do a deferential review. We're going to respect your expertise. We're going to respect kind of like a notion of reasonable finality as opposed to like the infinite chasing of an ever receding perfection. And that's why we do it. So rather than giving an example to talk about how that might work, I want to skip to the end so I have a little bit of time to cover major question doctrine, at least very briefly. I just want to urge everybody to take seriously the opposing instincts here. On one hand, Congress clearly, in fact, and maybe for blameworthy reasons, I don't know, Congress wants a flexible system. Congress wants a system that's going to be flexible on the ground to expertise and to evolving circumstances in an environment where it's hard to legislate. And expertise, I think it's important to emphasize, can be of two types. One is complicated, technical, sciencey, whatever. Science, right? Science moves, science changes, experiments happen, we learn new things. These guys say this, those guys say that, who knows, right? Like the whole problem of proving an evidentiary conflict in courts, like for purposes of, I don't know, tort liability. Think about that, but across the entire administrative state. One. But two, there actually legitimately really is an expertise in working within the confines of a particular legal regime over a long period of time. That's not to say that the judges have to and ought to listen to everything the IRS says because the IRS does a lot of tax law. But like ERISA, holy cow, that thing is so complicated with so many moving parts that there's really something to the fact of somebody who specializes in it over a very long period of time being more likely to get the right answer than a judge who is doing their very darn best. Their absolute best, and probably like amazing thinker, amazing legal thinker, top grades in law school, like best lawyer you could have. You know what? The further along you get in law, the more you realize, like, experience in a legal field matters a lot more than just being smart. And so, like, that idea of expertise in a really complicated legal field is part of the story as well. I have blown my time to talk about major question doctrine. I will summarize by saying it's about doctrines that are major questions. No. We can come back.
Practitioner and scholar, Mr. Nachmany.
Well, thank you very much, and thank you all for having me. I actually need to be the one of the panelists to say at the outset, the views expressed here do not reflect necessarily those of my employer. I want to say also I'm extraordinarily proud of the three Ls who pulled this together and organized really a magnificent conference. And I'm honored to be on this panel today in substitution for Jen Mascott, who's been an amazing mentor to me, and I'm thinking of her today and trying to channel her in my remarks a little bit. I was on my way over to this panel this morning, coming in from Boston, and I was on the T, and I get off the T, and the train, sort of goes away, and I'm about to head up the staircase at Harp Square, and I sort of look at the wall, and I see on the wall there's this sign that says, "Danger, third rail." Of course, if you grab the third rail, you get electrocuted. And it almost made me think of this panel in a way. And I think this is a really important point. After having read Jed's scholarship, Julian's scholarship, Chris's scholarship, and the excellent amicus brief you filed in the Relentless and the Loper-Bright cases, I'm not disabused of my view that the non-delegation doctrine exists and is a robust check on the separation of powers. I'm not disabused of my belief that the court should depart from Chevron. But I've realized, and I think this is going to be important for the folks in this room, that if you don't engage with the vast scholarship on these issues that calls into question some of the core foundational assumptions, or at least some of the most strident assertions of the existence of some of these doctrines or right answers, you might be grabbing the third rail. And so I want to structure my remarks today a little bit around some of the things that maybe Jed and Julian and Chris have taught us that when you are law clerks, you would be doing a disservice to your judge if you don't bring up. If you're a practitioner, you'd be doing a disservice if you don't structure your argument in a brief in such a way that engages with the scholarship. So I think it's likely, we can never say for sure, but I think it's likely the court will probably depart from the long-standing Chevron doctrine. I think it's likely that the court will continue to do major questions, maybe not go full bore on non-delegation, but in some way sort of check the the way that Congress either is able to delegate to the executive branch or the way that courts interpret those delegations. And I think we're going to see a continued focus on the unitariness of the executive, particularly as different presidential administrations change and there's more of a desire to remove folks at independent regulatory commissions who are seen as policy aligned with different administrations' priorities. But these aren't abstract changes. These happen in particular cases, right? So Jarkissi, for example, or Loper Bright, or Lucia, these are cases that came to the court because the government aggrieved a person or aggrieved a company or an entity or something in a particular way. And that person or entity or company has raised a separation of powers argument and said the separation of powers protects me. And so whatever it may be sort of in the abstract, I want that abstract principle applied to this particular case because it protects me. And when we're talking about the separation of powers protects individual liberty, what we're talking about is in individual cases, judges either interpret statutes in such a way as to prevent Congress either from delegating or from doing things that we're not sure Congress will do based on notions of separation of powers, or the court is exercising, we talked about judicial review, to say we're not going to give force to this statute because we think it contravenes the Constitution. Now, that latter thing is a really big thing to ask a court to do, right? And there might be some burden of clarity. And so the court has developed certain canons of statutory interpretation that may get us around the need to go and do the non-delegation doctrine such that we'll say a statute is unconstitutional. The major questions doctrine may be one of these, right? There's a debate whether the major questions doctrine is about enforcing the non-delegation doctrine as a method of constitutional avoidance, or if it's just a linguistic canon or something along those lines. And I want to credit Lou Capazzi, who I think is here today, who's done excellent writing on the major questions doctrine. But to be sure, not all non-delegation cases can be resolved by major questions. So at the least, major questions exist. It's not a perfect solution, but it's at least a way maybe to get around the need to do judicial review when maybe the evidence is not as wholly unequivocal about the existence of a broad non-delegation doctrine. But I still think that there is a non-delegation doctrine. And having read Julian's article, I think it's important to think about, well, what does Julian's article tell us? I'm talking about delegation at the founding, which you co-wrote with Nick Bagley in Columbia a few years ago. What does it tell us about the non-delegation doctrine and what survives Julian's article? So I have a theory, and I articulate this in an article of my own in the BYU Law Review, that there's a thing called the Article 1 non-delegation doctrine, and it enforces the Article 1 vesting clause. And we should read some of the examples that Julian puts in his article in light of Article 1. So for example, the Northwest Ordinance, which delegated substantial power in the territories. We might read that in light of the fact that that was Congress legislating pursuant to the Territories and Property Clause. And so maybe that example in particular forces us not to say, well, Congress can never delegate any sort of legislative power. We might say, well, if it's the Territory or Property Clause, that is something that may have some bearing a little bit differently than the Article 1 vesting clause. Still, you need to engage with it. You need to think about, well, what does this article change? How can we write the opinion? How should we write the brief? I think similarly with Chevron, right? I mean, you file this amicus brief in, Chris, the Loper Bright case, which says, Chevron has stare decisis weight, or, Chevron contributes to stability. And so we might not be able to say, well, of course, the case for Chevron is easy. We might need to engage the debate between you and Justice Thomas has said in dissents from denial. Well, actually, it's just a canon of statutory interpretation, so it's not entitled to stare decisis weight. But you should be familiar with that debate. You should think about it, and it should impact the way that you think about the vitality of some of these doctrines. It's an important thing. The final thing I'll note is, as you're thinking about, okay, well, non-delegation, major questions, Chevron, everything else, don't sleep on individual rights stuff as well. A lot of these arguments are based on the separation of powers and maybe contested notions of the separation of powers. I think the lively disagreement among this panel about what the proper role of the separation of powers is under a constitution and how it operates in practice. But doctrines like the void for vagueness doctrine or the rule of lenity and whether those apply and to what extent they apply in civil regulatory cases, I think is an important and interesting frontier particularly given that it might shuffle the ideological deck a little bit. There have been, for example, concurrences or opinions where Justice Gorsuch has been joined by Justice Jackson or Justice Sotomayor. So give it some thought, and especially, I guess, as the practitioner in this panel, I just want to make the point, it's important to use the scholarship. It's important to be aware of and well-versed in the scholarship, but it doesn't necessarily have to be the case that, something is put in a law review article and that's the end of the story. Just read the articles.
Thank you. Professor Walker?
Yeah, I like this idea of cite me more. I mean, definitely, on Chevron, I've got stuff for and against. You can just cite away. I'm not a legal historian, so, not unlike Jed and Julian. So I'm going to tell you a story that may or may not be true. And Bo Bauman, the scholars like Bo Bauman might call this administrative law Americana, or Phillipp Hamber might call it administrative law Pollyanna, but it's something, right? And this story is that we live in an era of presidentialism, over-presidentialism. We've seen a vast decline in federal lawmaking in Congress through legislation, and we've seen a rise of federal lawmaking through regulation. And in fact, in more recent years, we've seen major policy making centralized in the White House. Immigration is a classic example, whether that's trying to do deferred action for non-citizens, or it's trying to build a border wall without Congress acting. In other words, presidents, when faced with a Congress that does not want to cooperate or compromise or legislate, decide to go it alone. And this story actually gets worse, I think. Presidents nowadays say, I don't know where we get the power, but I'm going to issue an executive order or do a press conference or a tweet. I'm going to say all agencies find some old statute anywhere you can find it and use it to do something really aggressive and ambitious that I was elected to do. So that might be student loans forgiveness with the HEROES Act that was passed by a unanimous Republican Senate after 9/11. It might be climate change, one of the greatest threats that progressives see to the future of the world. Or it might be COVID response, nationwide vaccine mandates. I could go on and on. It definitely also might be a border wall and declaring a national emergency along those lines. And what we've seen is not stability in administration. That's not the value that we have. And we seem to see a Congress that's lost its ambition, or at least some of its ambition. And I'll kind of get back to that in a second. And in response to that, the same court that Julian, or actually Jeff focused more on this, that you see a rise of unitary executive theory at the Supreme Court. You also see a Supreme Court that's really pushing back against the president and trying to push Congress to do its job. So I'll give you a couple examples. During the Trump administration, I think we saw a harder look review. If we publicly know that an agency is lying about why they're trying to add a citizenship question to the census, courts are going to say pretext isn't enough. If you're going to overturn a prior policy on immigration relief, and you're going to say the only reason you're overturning it is because it's unlawful and it's not unlawful, you're going to be forced, the president, you are going to be forced to provide policy reasons for why you're departing from a prior administration's approach to immigration. So that's one. The other one Julian touched on a bit. We have this major questions doctrine now that the court has invented or refashioned to try to force Congress to make major questions, or at least to make sure that agencies don't answer major questions if Congress hasn't clearly authorized them to do so. And then you have, of course, the current debates on Chevron that Ellie mentioned, where the court is exploring how to either narrow or eliminate the deference that agencies have traditionally gotten for their statutory interpretations. And then in the backdrop, you have non-delegation, right? So the court is pushing back. Again, this is the story I'm telling, and historians will tell me whether I'm wrong, on this idea of over-presidentialism. Now, my question is Congress going to find its ambition from this judicial pushback? And I think the answer is pretty clearly no. There are deeper problems with Congress in getting rid of Chevron or adding the major questions doctrine or doing a harder look review or even reinvigorating the non-delegation doctrine, whatever that means. I still don't understand what that means, but maybe Ellie will tell me what that means. Isn't going to get Congress to work. So what do we have to do to get Congress to work? Well, one, I way oversimplified. Congress does work. a lot. The Biden administration's had a pretty successful 4 years on the legislative front compared to some prior years. But more importantly, they do a lot of important oversight along those lines. So like Josh Chaffetz's book, we can do a lot more oversight. Congress will do a lot more to fight back against agency overreach than it currently does. It has tools to do that in the Constitution and its own rules. So that's one. Two, as Julian Metzger says, we can take appropriations seriously. That we can really, Congress can use its appropriation power, its power of the purse, to rein in what agencies are doing, to exert additional oversight in ways that fall short of traditional legislation. Another one that I've suggested, and Ellie foolishly published it in the Harvard Journal of Law and Public Policy, is that when it comes to major questions doctrine, we should make it easier for Congress to answer those major questions. If a court says it's a major question and says the agency can't regulate, we shouldn't have a filibuster for an up-down vote on whether this current Congress thinks the agency should have that authority. Really easy way. Not so easy, but it's easier than what we have right now. Similarly, these old statutes that are not being updated by Congress to govern agencies like the Clean Air Act, that's dramatically not tailored to deal with climate change, Congress should be forced to reassess these statutes. And Jonathan Adler and I have explored that in an article called Delegation of Time, where at least for some agency statutes, we should have mandatory authorization, that they should sunset, forcing Congress to come to the table to update statutes to deal with new problems. Another one which I don't have time to talk about is Congress has anti-removal power. So if we're worried about independence in agencies, Congress can raise the costs of removal on the president or on the agency heads if they're removing lower level inferior officers. Has a lot of tools in that toolkit to send a message to the executive branch that we want science, we want impartiality, we want independence to some degree within federal agencies. And the last one, and I know I've already lost half the room on this, is we have to build a political constituency for this. I think some of you are very, very happy with the fact that the federal government won't do anything after the Supreme Court implements all these doctrines. That's what you want, right? Others of us talking about separation of powers, though, view Article 1 and Congress as our primary legislator. We want a vibrant Congress that makes the major value judgments at the federal level. And so my pitch is more to those, but we have to build that political constituency to really reinvigorate Congress's ambition. And if we don't, we're going to end up with a federal government that doesn't work for the people, doesn't work at all. And again, I know some of you are pretty happy about that, but that doesn't make me too happy to be electing people that are just going to sit there and run for re-election again.
Well, there's a lot to unpack there. First of all, do any of you wish to respond to what's been said by your colleagues? I know Professor Mortenson didn't get a full-on discussion of the major question doctrine. I don't know. Or if any of you wish to respond to some of the comments that have been made.
Can I engage Julian?
You certainly can.
As someone who's, been in print and now vindicated, I'll explain. I want to pinpoint what you now identified as what was important about Chevron and how the major question doctrine addresses Chevron may be valid in mid-level cases, but why majorness is especially appropriate without deference. So part of what I heard you talk about with why Chevron is valid, let me break it into two pieces. One is a matter of triage and judicial economy. This is maybe the best explanation for Chevron is that with the growth of the administrative state, there were just too many detailed questions of expertise and a mammoth. There's a reason why Chevron is the most cited case in American history. It's because there are so many cases of statutory interpretation that come up. So when it comes to mid-level issues, there's a judicial economy triage point. The counterpoint to that is when it's a major question, that's precisely when you shouldn't triage. You should take those cases, and then you have the majorness as a reason to dig in and do extra work. And then the second, and maybe I'm projecting this, but I thought maybe you were hinting at this too, which is on expertise. Oh, you did say this. When it comes to expertise, there's an importance to defer to agencies on expertise. When it comes to, this has always been Chevron was wrong the day it was decided. But one of the reasons why it was wrong is for the reasons we heard in panel one, which is it is. I talked right there. Applaud. You gotta know your audience. It was wrong that it was decided because it is the province and duty of the judiciary to say what the law is. So on policy questions, hard look doctrine. I also want to note, Chris, I think you're right. I think we have a new question of what something called super hard look. Several of us have called super hard look doctrine, which is regents. But back to the point of the major question doctrine, when so the reason why Chevron's always been wrong is statutory interpretation is the domain of the judiciary. But that's the most true on a major question because then the institutional gap, right, the relative expertise or the comparative advantage of the judge versus the agency is either minimized or zero. Because the more major it is as a question, the more it incorporates a question of public understanding of the statute and the debate. And there, the judge is on a stronger basis, maybe because the judge lived through that passage of the statute. And so then the question of majorness is that the judge has not only the relative expertise over statutory interpretation, but there is the gap on the details versus majorness is eliminated by the majorness. So I've got other questions about it, but I wonder if you might talk about that issue.
And when you do so, we have quite a few 1Ls in the room, and can you give an example of what this major, is this major in the eyes of the beholder? What are we talking about here?
So first of all, yes, it's major in the eyes of the beholder. And what could go wrong there? So it's interesting. I've never quite thought about it the way Professor Jed just presented it, in the sense that, it's both a gap in my thinking about it, but then also maybe suggestive of the answer. I've never thought about Chevron as a triage. If you think about Chevron as a triage of attention in respect to overburdened courts not being able to do the job they're supposed to do, then I agree, actually. The major questions doctrine makes sense, and I may just not read enough of the field, but I've literally never quite thought about that before. But that suggests my answer, which is I don't think about it as a triage doctrine at all. Triage is sort of a nice little side benny, I guess, but the real point of it is the underlying, again, on the face of Chevron. Chevron doesn't talk about triage. Chevron talks about the underlying theory of how statutes work. It's actually a super fascinating case, and I love teaching it because, like, every time I teach it, I see like a new sentence. It's like, oh, that's a great point. So go out and read Chevron again. It's very clear about the idea of interpretation spilling over in this messy way into an assessment of how the world is. And I kind of referenced it here as a law-fact distinction, which is not really how Chevron talks about it. But if the idea is that Congress elects to create a system in which decisions about whether to regulate that chair or not turn on some kind of combination of science and prescriptive law to tell you how to apply the science, then, like, unless the chair guy really screws up, Congress meant for the chair guy to have space to decide, this is a weird analogy, how to do chair regulation, right? It is a substantive view. I'm speaking descriptively about it now. I mean, I guess it's probably apparent I basically buy into it. But it's a substantive view about how the administrative state, in fact, works, and in fact works in the sense of is meant to work by Congress. And I think it's a historically accurate description, which is one of the reasons that I struggle so much with the major questions doctrine. I mean, it is often, this is not my lead argument, it's more like isn't it an ironic argument, but it is often suggested that the problem with delegations is it lets Congress intentionally punt what? Major questions. So, like, to the extent that you're rooting major questions doctrine as any kind of canon that's trying to channel either text, context, I won't say the words intent out loud, but something like that, right? Like, it's not reflective of the historical story of these statutes. And so the attempt to ground it as an emanation of Congress, I think, is problematic. I will, in response to Judge Elrod's question, or suggestion, I should say, for an example, I'll give two. I had a few, but I'll give two, and then I'll stop. I won't go on too long. But the one that I think is really useful, because it's a case where my instinct is, that can't be right, and it's a case that's talked about, it can't be right that the statute lets this happen. But it's also a case in which it's talked about it as a major questions doctrine. And I'm like, that's not it at all. It's the case involving the eviction moratorium, right? The eviction moratorium, well, first of all, what is the state, I mean, as sort of enunciated in West Virginia versus EPA. Here is the one-sentence version of the major questions doctrine. Would Congress have intended to delegate a decision of major economic and political significance to an agency in a cryptic fashion, right? That's sort of the lingo that is glossed by major questions doctrine. So here's the statute in the eviction moratorium case. I'm terrible with case names, so I can't even remember which case it is. But the statute says...
It's Alabama Realtors.
That one, realtors, that's right, realtors, that makes sense. The Surgeon General, I mean, I really am bad with cases. I tell my, okay, all right, teacher thing.
I'm a legal realtorist.
This is what it's like having to hang out with Jed. I will, which is great. I actually do want to make a teacher point thing here, which is that I really am bad with case names. And I think that's a thing that students often get super self-conscious about. They don't remember the case name and they freeze up and it's like, oh my God. But you can say the eviction case in the context of a conversation, perhaps Judge Elrod will agree, even during oral argument, and it's okay. It's
Absolutely. That's what you should do because we may not remember the name of the case either.
Yeah. Okay, so back to the statute in the eviction case. Realtors, Alabama realtors. Alabama? Alabama realtors. All right. The Surgeon General now. The Surgeon... Roll Tide. The Surgeon General. All right, just pause on that. The Surgeon General. This is the eviction case. Okay. The Surgeon General can make regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from one state or possession into any other state or possession. And the regulation is, under certain circumstances, and I didn't write all the details down, you can't evict people for some period of time during the cresting, rising tide of COVID, in part on the theory, and I don't even think it's just a theory, I think it's actually probably definitely true, that like homelessness and inability to be in a place creates unsanitary and unsafe conditions, creates transience, spreads COVID. Like, I actually buy the theory. But now back to the person who's making this decision. This is the Surgeon General making an intervention into the national housing market on the basis of a statute that's oriented at Surgeon General-y stuff, i.e. like medicine and how we do, how we structure like care and what the science tells us about this drug versus that drug. People who do health law are now like rolling their eyes at me always. I do not understand the Surgeon General's job. But the reaction there, and I think it's a fair one, and it is my reaction, I don't know enough at the end of the day beyond just reading the case about the statute to know there's no danger of my ever being on a court, but of how I would have ruled. It's like, oh, come on. That's not the kind of thing that the Surgeon General is going to be supposed to do. But that's not because it's a major question. That's because it's like a silly reach of an interpretation where the overall structure of the statute and who's doing it tell you that that's not the kind of thing this person is supposed to do. Why do we know that? I'm allowed to say purpose now, again, in legislative and in FedSoc circles. I'm so glad. This is great because of like legislative purpose and spirit and stuff like that, right? We're going to look at the deep sort of meaning of the statute and does it make sense? And you guys like that now. And so like, good. Right? And so like that version of the major question works for me, but I don't think it's a major question doctrine. I think it's like, think for 3 seconds about the purpose of the statute doctrine. I'll leave it as a question. Does the major question doctrine apply to Hamdi? Background statute in Hamdi says, can't imprison Americans without clear authorization. Non-Detention Act. Really big act, not like an afterthought, passed after the internments, Japanese internments. Big deal, right? Like, not just an afterthought, big deal. Authorization for the use of military force says, all necessary and appropriate force to respond, and then it names certain people. Stipulates that Hamdi's in the group of people. Is detention of Hamdi on an indefinite basis without access to the ordinary laws of war clearly authorized by necessary and appropriate force? Or, my friends, is that a major question? And if it's a major question, right, like, that's the way I want to land. If it's a major question, then I think it goes beyond saying don't defer to the executive. In fact, I know it goes beyond saying don't defer to the executive. That's the twist that's happened with major question. Major question used to be, it emerged as like a reason not to do Chevron and to rework the analysis from the ground up. It now works as a constraining, it is a constraint, a substantive constraint on the otherwise natural meaning of the statutes involved. Natural, best, whatever the word is. Like, I'm not a theory guy, but like whatever your best reading of the statute is, if that seems too big, then you squish it down. That's the major questions doctrine. And it doesn't have anything to do with whether the agency's interpretation is deferred to or not. It now is a doctrine of like limiting the obvious textual reach of statutes. And I don't know, I just don't think that if the effort here is to serve as I'm getting on a pedestal. From my perspective, it seems to me that possibly there might be downsides to structuring the job of a judge to decide which questions are too big and which aren't, and instead just do your best to interpret the statute for what it says.
Can I respond to Julian?
Sure.
So, I want to push back on the idea that FedSoc is now into purposivism because of the major questions doctrine.
I'm sure there are sighs of relief in the audience, but
I think the major questions doctrine does one of at least two things, depending which camp you fall in, and these rationales come together in some of the opinions. I think you might see both of these themes in West Virginia v. EPA. The major questions doctrine, number one, might be a substantive canon of statutory interpretation in that, and we talked about this a little bit earlier, it enforces a particular view and maybe more of a particular fear about engaging in judicial review on non-delegation doctrine grounds. And so if the court interprets the statute in such a way as to say, no, there's no delegation problem here, really because there was no clear statement from Congress, we're not going to assume that the Congress delegated as capaciously as the litigant asserts that it does or the executive asserts that it does. Therefore, we don't have to declare the statute unconstitutional on non-delegation grounds under the governing precedents. The major questions doctrine allows courts to do that. It is a time-honored tradition of courts when engaging in statutory interpretation to do constitutional avoidance. And so you might call the major questions doctrine a sub-canon of constitutional avoidance, not purposivism, just one of the traditional canons. The other one, and this is Justice Barrett's concurrence in Biden v. Nebraska, is that actually the major questions doctrine is what we would call a linguistic canon. It is an assumption about the way that Congress, or the way really that people speak, and what assumptions can we make when legislatures say a certain thing. So some of these, those of you who have taken either legislation and regulation or have engaged with, the canons of statutory interpretation will be quite familiar about, and you won't really think that there's much of like a dice loading element or like a policy laden element to it. So the expressio unius canon, and a lot of these are like Latin canons, but the expressio unius canon is one of them. And you might say if Congress says something here and then it doesn't say another thing, well, we take its lack of saying that other thing and the fact that it said thing one to be at least somewhat determinative of what the meaning of the statute is. Major questions doctrine says we couldn't assume that Congress would delegate such a major authority or would speak on such a major question if it wasn't going to be unambiguously clear. That if Congress is going to let the executive do a really big thing, let's at least make sure that Congress meant to do it. And so I think that's how you elide the purposivism charge that the major questions doctrine in some corners I think has brought up. But I just, and I'll finish on this point, I wonder if the major questions doctrine is enough, because I'm concerned about describing it as a rule of triage that seems to me inconsistent with the rule of law. It may be the case that our society, it goes back to my remarks from earlier, maybe the case that our society cared a lot more about the outcome in, say, West Virginia v. EPA or King v. Burwell or FDA v. Brown and Williamson than it cares about a workaday statutory interpretation case about some interstitial policy thing that goes on in a statute. But I got to tell you, that case is really important to the person that brought it. And if that case leads to a deprivation of property or deprivation of liberty or some adverse consequence against the person who's litigating that particular case, cold comfort to say to that person, well, we defer to the government on this case because, we just don't really have the time. We're only going to do real statutory interpretation in the major questions cases.
I agree with that. I think a description of triage. But that's your normative point. I 100% agree with. One small sentence on this is for the people that are worried about what are you going to do if Chevron goes away. I say, worry less, skid more. And so out there, so there is skid more. But the point is that you should defer to an agent like skid more. All right. How about this? I'll pun less. And more. So okay,
I'm stealing that for terrible law night games. I mean, that's just terrible. But but I'm sorry. Is that okay?
Look, I'm relentless. What can I?
So ruled.
But
Relentless.
Oh, that's so funny.
I'm looking for the Loper Bright side of all.
Have you practiced these at home before you came?
I get on these MQD panels.
But what does Skidmore do? I mean, I know what it does. I mean,
Skidmore makes a ton of sense.
but does it
because
do anything?
Yes, it's weight, which is all that they should give to agencies. Now, weight means look to an agency where it's appropriate, and weight is not deference. Weight means that an agency has a burden to be persuasive. So the degree to which the agency shows you that, well, it turns out this word might have looked like this, but the agency explains, there often is a relationship between agencies and the way statutes get written. And so it turns out that if an agency could show, and this is again, I'm an originalist, but not a textualist. I'm a purposivist, and I think the major question doctrine is purposive. So in the Cato piece that I wrote, I explained this purposive background. But the point about Skidmore weight is that if the agency is persuasive and they can show you that there's expertise, you give that weight, but in the way that that statutory interpretation should happen all the time. It should be a factor, but not a rule.
Professor Walker, our pragmatist down at the end of the table, if I may call you such, what in the world do we think of this? You know, we're asking whether Congress really intended to delegate such power. It sounds like from some of your earlier remarks, and I don't want to put words in your mouth so you can correct me if I'm wrong, that you say, yes, they didn't really want to do the legislating because it's a lot of work and we don't even have legislative staffs anymore to actually write laws. And there's other things we can do, oversight and other things that are, so the answer is yes, we're happy to delegate it all away. And so, you know, what happens in that world? And do you have anything else to add that they've been talking about?
I don't think that's me, but I do think
Okay.
and I think there are probably a few of us still in the room of kind of traditionalist Burkean conservatives that think that the law should move slowly, that think that we should defer to political branches on major questions. Not saying the major questions doctrine is wrong. That actually might be a way to do that, right? I'm going to leave that on the table. And when I think of Chevron, I think of it as judges looking at a statute and being humble and saying, you know what, as Justice Stevens said in Chevron, we're just not sure if Congress spoke to that question. And because we're not sure, and we are sure that Congress did say, and the Secretary of Education shall have the power to promulgate rules to implement that statute, we know that Congress wanted the agency to implement the statute. It's in the statute. We're going to be humble about it, and we're going to defer. And that has a number of really important values, as Justice Scalia taught us. One is that it leads to uniformity in federal law. Peter Strauss has this great article from like a decade ago so called 150 cases. And that means that the Supreme Court only hears 150 cases a year. Turns out we're at like 67 or so. I mean, we're not even 150 anymore. They can't make all the wrong decisions in the circuit courts right. They can't bring uniformity to all the chaos. But Chevron brings a lot more uniformity because it encourages judges when they have humility and they think, gosh, I can't tell whether Congress spoke to this question of statute and the agency's charged with administering, of deferring to that agency. And I think that's a really, really important part of that. The second part of being a old school judicial conservative is that we're deferring to the political branches. One of the Bens last night said that the FedSoc motto is to say what the law is and not what it should be. That's judges' roles, right? And I've heard that numerous times when I give FedSoc events across the country. Part of taking that seriously is the humility to recognize that when there's uncertainty in a statute agency administers, that there's a temptation for judges to insert their own policy preferences about what that statute means. And those policy preferences aren't reversible these days because Congress doesn't act. And that's a really dangerous approach, whereas they are reversible if we have a new presidential administration or we have a Congress through appropriations oversight exerts pressure. So I think when you're thinking about Chevron, the values of Chevron, or at least some version of Chevron, are that it puts political accountability where it should be. It helps judges to do the job of judging and not policy making, and it leads to greater uniformity in law. And that's what I worry about getting rid of Chevron, and like really getting rid of Chevron, that we end up in a world where judges are all three branches and we don't have separated power anymore because the judges are the ones that are doing everything.
I just have a very quick question for Chris, who's the mega expert on this space. If Chevron is eliminated and we fall back into Skidmore, how long will it take for there to become a Skidmore step 0?
Yeah, it'll be quick. Yeah, I mean, I think we'll just self-replicate Chevron and Skidmore. So Kent Barner and I, this data's old now, right? 11 years ago, we read every single Chevron case in the circuit courts and coded for 70 different variables. And it turns out that agencies win under Chevron about 77% of the time. When they play de novo review, they win about 40% of the time. Now, there are a lot of methodological reasons why that's extreme, and it's probably not that extreme in practice. Under Skidmore, they win 65% of the time. So it's not de novo review. I think we will still see some deference. But I think Judge Elrod really hammered home, for some judges, it's no deference. And for other judges, it'll be like a Daubert standard, that once they decide that the agency is an expert, they're just going to defer. And so you're going to have a lot of disuniformity in federal law, where some judges are doing some things, other judges are doing other things. And
Well, even under Chevron, they were supposed to take a robust number 1.
Yeah.
We were talking about that
Yeah.
last night. Judge Kethledge was talking about, there is prong 1 of Chevron, and so sometimes there is no deference at all. So, but even under that world, but you think it's going to be a difference?
I think it will. I mean, eventually the curve of those of you who end up clerking and dealing with FERC cases or ERISA cases or very complicated cases that has a scientific record. The reality is judges are going to end up deferring to complex matters, hopefully, because they have the humility to realize that this is just not an area where judges are going to be better than agencies.
You say hopefully.
Yeah.
So as between unaccountable judges wearing too many hats under your view of the world, and unaccountable very smart people, could we call them bureaucrats, or is that
I like bureaucrats.
is that appropriate? What would you, whatever the
Well,
nice
I mean,
name,
I think
if
that's-
you think it's better to put it in the hands of the unaccountable bureaucrats?
I think it's
Because- is
absolutely
that
better for
because
federal agencies to get
even in
deference.
things that have nothing to do with
Well,
science or math or
Yeah, and I think this is where, I do think this is where the unitary executive turn is helpful on this front. I mean, unelected bureaucrats are not making any major decisions anywhere in our federal government. Point one example where an unelected bureaucrat did something that didn't have a political head review of, or didn't have Ricky Gervais running the Office of Information and Regulatory Affairs, reviewing that decision before it becomes final in the White House. We live in a world where presidents make those decisions, and if they're controversial enough, Congress calls an oversight hearing and applies pressure, threatens to take away appropriations. So I think unelected bureaucrats played a very important role in constraining presidents from violating the rule of law or from ignoring science or otherwise. But they're not the ones making the decisions these days. We have a unitary executive. And I think that's a feature of our current system, that political control is so strong at the final decision-making process.
that's a feature, not a bug, to have be able to have an executive
Absolutely.
who even if they say, as you said earlier, this isn't really the law, or someone said, maybe you said this, I can do it anyway, and nobody has standing, although to challenge it. And we had a panel not too long ago about the special solicited. I mean, that's an okay system.
Well, I don't love the rest of it you put in there, Judge, but I like the idea of final decision-making authority by a politically
But,
accountable
okay,
head of an
Professor
agency.
Shugerman has some thoughts on this.
That's right. Judge Elrod did a great job of circulating some questions, maybe even major questions, to us about these different issues. And it turns out that some of the questions she circulated, Chris, you just picked up on a key point. So let me make, as long as maybe we're pivoting to the unitary executive piece now, let me make 3 points about the unitary executive. The first is the segue between the major questions doctrine to the unitary executive. This is a contradiction. This is the deep tension right now is that the Roberts Court is making some audacious and ahistorical claims about the presidency that are in tension with this major question doctrine that you just, you're shaking your head, but I'll have you
I'm
nodding
doing
in a
the
minute.
Alito. There's just not true.
So Jody
Not true.
Short and I just published, it's just out this month in the Boston College Law Review called Major Questions About Presidentialism. And here's the contradiction, that the way the Roberts Court talks about major questions cases is they talk about unelected bureaucrats making these decisions. And we went through all of the cases, and they don't mention a single president's name, even though we all call it Obamacare. King versus Burwell didn't mention Obama once. They talked about the ACA and unelected bureaucrats. So this happens over the only time that in any of the canonical or in retrospect major questions cases that the Supreme Court mentions a president is in Biden versus Nebraska, and instead of giving the unitary executive credit for the legitimacy of it coming from a president, they blame Biden for they quote Biden to show that the purpose didn't match. Why is this problematic? It's because in a parallel set of in a parallel cases that we're going to talk about in a second, the Roberts Court is exaggerating Article 2 and making up theories of presidentialism to legitimate the unitary executive. So the contradiction is that the legitimacy explanation, the democratic legitimacy explanation in the unitary executive cases is gerrymandered, if you will, to just removal and appointment. But when it comes to Chevron and major questions doctrine, the superiority of the president is ignored. So let me give you two passages that are not historically grounded as a basis for saying that the president is the most legitimate democratic representative. So in Saylor law, Roberts says that the president is the most democratically and politically accountable official in government because, quote, the president is directly accountable to the people through regular elections. And furthermore, so that's just a historical whopper because 2 days before Saylor law, Roberts voted in a case called Chiafalo, which was about the Electoral College, which contradicts this idea of directness. It turns out that this theory of presidential representation or presidential superiority, I'm not saying presidential supremacy, but what Roberts and the unitary executive theorists are propagating is this idea of presidential superiority, presidential specialness, presidential representation of the nation. If that, don't gerrymander, first of all, there's a gerrymandering of that to the unitary executive cases and an avoidance of recognizing that there's legitimacy if to major questions that should at least be, let's say, like not Skidmore weight, but presidential weight. So there's a contradiction there. So let me just say further, Judge Kethledge last night made a very interesting point about the word all. And it happens over and over again. So, and it's one I agree with. In fact, I wrote an article that relates to this, right? So in Article 1 says all the legislative power herein granted in the Constitution shall be vested in a Congress. And last night, Judge Kethledge emphasized that all has to mean all as an argument for the non-delegation doctrine. So let me pause for a second. I dug into the vesting the word vesting in an article in the Stanford Law Review. And it turns out that vesting, vesting doesn't mean what some originalists think it means. Like it's, like this is the Princess Bride rules. Like it's inconceivable that the word all might mean all. Well, the word vesting might have this role. But as Judge Kethledge last night has done something that both Justice Thomas and Justice Gorsuch have done in the non-delegation cases, which is to highlight the word all. I'm not going to explain further, but I actually think there is good grounding that even though vesting didn't have the powers of indefeasability that are part of, Julian uses this great phrase of semantic drift, that the word vesting in the 19th century meant legislatively indefeasible. It did not have that meaning in the 18th century. So the word all is, in the research I did, I showed that vesting had lots of flavors, but something being all vested or entirely vested had special significance. But then on the flip side, that's been gerrymandered to Article 2, to Article 1. If all is significant, then what is Scalia doing in Morrison versus Olson when he says, well, the executive power in Article 2 means all? Well, so which is it, right? I mean, do words matter to textualists and originalists? So there is a problem of emphasizing all when it's convenient, but saying the means all when it's convenient. And this is also a problem in Article 3 because Article 3 says the power. So the final thing I'll say about this is the significance of the assumption, right? So maybe I'm directing this to Chris, right? The unitary executive theory has an evidentiary crisis right now. And so there is an assumption that is projected back on the past that executive power must have implied removal. And the research that many of us are doing, and let me name check, Andrea Katz and Noah Rosenblum at Washington University, Noah Rosenblum at NYU, Jane Manners and Lev Menand and I've just placed this article in the Notre Dame Law Review as of yesterday. Any Notre Dame people here? It's like, I look forward to working with you if you're, and thank you. But it turns out, very briefly, that the history is more complicated. And it turns out that over and over again, officers had a freehold interest. Many officers in England had a unremovable freehold office, of property in office, and were unremovable even at the level of cabinet, even at the level of department head, though what a department head was very different back then, and in Treasury. And so there is no evidence, there is no evidence that holds up to scrutiny that the phrase executive power implied or included removal. And so I'll pause there, but I think that this is a question that just has to be addressed in the questions of unitary executive.
We're going to be moving in just a moment to the question from the audience time. So be thinking about your good, succinct, and I emphasize succinct questions, not soliloquies. Professor Walker, you had something you wanted to add?
I just want to real quickly on the, again, I don't do history. I can tell you, like, we live in a unitary executive world now as a matter of politics. Like, President Biden, if he wants, will make every decision in the executive branch, and so we can fight about what the court's going to, but this is where we are, right? But I don't think the major questions doctrine is at all inconsistent with the unitary executive as a policy matter. I think what the court is doing is saying, whatever power you, president, or the executive branch agencies have through Congress, through statute, the president can exercise it, but we're not going to let the president or agencies exercise power outside of that. And we're going to really patrol those lines. And I think that's internally consistent. I think it makes a lot of sense, and folks, progressives like Dan Farber have written this up. And I really do think the major questions doctrine is actually more geared at the president than it is at unelected bureaucrats or bureaucracy more generally, that it really is a signal to the president. Don't use old statutes to do new things.
Did you want to say something?
Yeah, I mean, I just wanted to make note, right? You cite the Katz-Rosenblum article, but you neglect to cite what it responds to, which is Bamzai Prakash. So I think there's important scholarship on both sides of this issue.
I've got to pause. So on my handout, I've raised on the Bamzai and Prakash evidence. You can read it for yourself. I've posted on NSSRN already a lot of questions about their use of
This is
sources.
why we're so grateful to have different perspectives come to the meeting and be able to debate on and discuss these issues. And it's really telling that professors who might not ordinarily have been interested in originalism, but who are interested in history, have chosen to engage in the originalism discussion. And not just said, oh, that's for those people over there, but you've engaged robustly, and that's to the credit of you, professors, that you are engaging. I know that you said that you're not a textualist, but and it reminds me of Justice Kagan saying we're all textualists now. But it sounds like, at least for some of us, we're all engaging in originalism inquiry now. And that's probably very valuable to the practitioners as well as the academy, and to the judiciary as well.
Sorry for interrupting.
That's Professor Mortenson. Did you want to respond to something that Professor Judge Kethledge said?
I interrupted Elliot on that point, so
I'll give Professor Mortenson the last word.
Okay. So gracious. You don't have to. Professor Shugerman pretty much
I cannot
already
tell you
made
how
all your
wrong Judge
points.
Kethledge is. That man doesn't know.
He's very fond of you.
I'm pretty fond of him.
Just not your article.
I'm pretty fond of him. No, we need, Judge Kethledge is fantastic. We should have a judiciary with more Judge Kethledges on it, I think, for sure. So two things. First of all, actually, it's interesting, just because the little thread that you raised is interesting to me. The idea of somebody who's not an originalist, and man, am I not an originalist, getting pulled into I mean, that's too passive, entering into these conversations. Because it's sort of like for those of you who are out there who are interested in academia, it's an interesting story about somebody who didn't start off interested in academia, but absolutely 100% all in on practice, actively chose not to go into academia, got drawn towards academia, which is, I worked on a whole bunch of sort of war on terror stuff during the second Bush administration, both first and second terms. A lot of that stuff came before me, good Lord. My apologies, Judge Elrod, came before us in chambers when I was clerking, and I just mean that I read it when I was clerking. And as a litigator, eventually, I had really strong views on how it seemed to me that the things that were happening were bad, and I'll leave it at that. And I was interested in using my intellectual energies and legal training to try to push back against bad things. And then it turned out that like this intellectual move at the heart of like a remarkable number of arguments made by, in particular, the Office of Legal Counsel, but also important justices on the Supreme Court, is like the executive power being vested in the president. And I won't go on about that, but it just turns out that's like everywhere in any brief, in any memo that anybody wrote ever about anything to do with the war on terror or other military-related things. And you know what? That's like a historical question in a time of originalism. So like, why don't I take a look and see what it says? And the more I dove into that, first as a litigator trying to see like, well, what does Blackstone say about it? Doesn't quite seem like what they say about it. Right? Like there's that sort of like litigator's excitement of finding stuff that's a good pushback. But then I suddenly found myself like, whoa, this is really cool. Like, this is actually really, really, really interesting. And I like reading this stuff. And I think I want to actually really, really figure this out. And so that's sort of, I don't want to say I literally only went into academia because of trying to figure out what the executive power means. But that and then lots of stuff that has been thrown off by that has become my project really as a story of an absolutely 100% ideologically motivated starting point. But within my ability to subjectively report accurately, became over time just trying to figure out something really complicated that doesn't actually map onto either our present era in really important ways, or in some respects, my own preferences. I'll footnote by saying I'm not entirely thrilled about the fact that there was no non-delegation doctrine of the founding. I would prefer that there be one. And I haven't answered Judge Kethledge, but I've talked too long. So if somebody wants to talk about non-delegation during Q&A, open to it, but I should stop.
Okay. Questions? Yes, sir. You. And then you're next.
Thank you for this. I'm John from Columbia, and we talk a lot about financial regulation, and some of the FinReg people are concerned about the independence of very important agencies like the Fed, the financial stability regulators, maybe even environmental regulators who should prioritize long-term financial stability or conservation over the short-term 4-year or 8-year time horizons of a unitary executive. And so we've talked about separation of powers and the intent to prevent tyranny by separating powers into 3 branches in the Constitution. Do you think there's an argument, or what do you think about the idea that these sorts of new parts, smaller branches of government, were created by later Congresses, intentionally independent from the unitary executive, with longer-term interests, time horizons in areas where you need a lot of expertise, and that's honestly a more accurate or more faithful, I guess, implementation of the founders' intent to prevent tyranny by separating powers than a rigid adherence to the 3-branch model. Is that an argument for, uniting separation of powers with independent administrative agencies?
Thank you. Thank you. Would you like to handle it?
I'd be happy to take this one. I think there's an assumption built into your question, and that is that the president or that, the unitary executive is incapable of dealing with long-term problems. And I take your point, right? It may be a bit dismaying to look at presidentialism today and wonder, are presidents capable of doing the things to put our country on the right path long-term? And is that an argument maybe then to take a little bit of presidential power away from the president and vest it in somebody we trust, right? Somebody who's an independent agent for this particular thing, this really important thing, this thing that requires long-term thinking. But I think about how John F. Kennedy, right, put together a long plan to put a man on the moon, how Dwight Eisenhower put together a long-term plan to build an interstate highway system that many of you probably traveled on to get to this event today. And I just wonder if it's necessarily the case that we need to take, for example, long-term environmental regulation out of the hands of the president just because the president will only happen to be in office for 4 years or 8 years. When there's plenty of things that presidents do that reverberate for 100, 200, 300, I hope 1,000 years after they spend their time in office. And I would think, maybe I'm wrong, but I think the president might be thinking about that when she or he is in office. And so I don't buy the assumption. I don't know. And maybe it's the case that the president will be thinking short term, but then that's our job, isn't it? To vote for people who are going to advance long-term policy solutions and long-term policy goals and stick to it when in office, as opposed to saying, well, this thing's really important. Let's take it out of the hands of the president and give it to somebody who's unaccountable.
Can I add, or disagree a little bit on that? I mean, so when I think of classic independent agencies, I'm thinking about regulating financial markets, regulating elections. Used to be telecom, and that seems less relevant today. And I don't love the idea of presidents regulating elections or president swings affecting financial markets. And of course, the big elephant in the room is monetary policy. I don't think those are areas where we want presidential elections to lead to big swings. I'm the U.S. Chamber of Commerce guy here, right? And so I do think there are really important constraints that we should put as a matter of norms, and we see that with the Fed, and also just a matter of removal costs that Congress can impose to make sure that presidents aren't running roughshod across areas where we care about stability a ton. So I don't have a lot of confidence in whoever's going to be the next president or who's the president now dealing with elections or financial markets. I definitely don't have confidence in any of them dealing with monetary policy. So I would love for the norms and the processes to kind of insulate that, at least to a certain degree, from the presidential politics.
Okay, next question.
Hello, my name is Nachmany and I'm a 3L at George Washington. And this is a question for Professor Walker. You sound to be very optimistic about the role of unelected bureaucrats in the government and the fact that they somehow serve as a check on the abuses of the presidential. I wonder, how do you reconcile that with the fact that these unelected bureaucrats' inactions and delays can also be a violation of people's rights, for example, in instances of such as immigration and things like that?
Yeah, love it. So I'll focus on 13,000 unelected bureaucrats, which are our agency adjudicators that deal with immigration, patent rights, Social Security. I want those agency adjudicators to be as impartial as possible. I don't want an agency adjudicator to look at a case and say, I know the facts here mean the law means this has to be the answer, but I know that my political boss wants a different answer, and so I'm going to rule against the non-citizen or against the patent claim or against the benefit case or in favor of it, right? So I think when you think of how in the Administrative Procedure Act, what Congress is trying to achieve is in the standard model of agency adjudication is that those career-level unelected bureaucrats have a level of decisional independence to create a record, to find facts without bias, and to apply law to facts. And what that makes that work, though, under the Administrative Procedure Act, is that the political head of the agency, who reports to the president, can make the final substantive decision. And I think that's the way that the administrative state has to work. I think if you care about liberty and tyranny and all of that, it's a much worse world where you don't have folks with some level of decisional independence on the trial level, on the kind of, that do that. Now, on the flip side, I do agree with you, although I think that it's a huge empirical question. What about these roadblocks? I'm on an HOA board right now, and we're, several of my board members want to add another 30, not 30, I'm exaggerating, speed bumps. And it's going to be really hard to get from one end of the neighborhood to the other. We already have 8 speed bumps. I think that's probably enough for one neighborhood. But it's going to be hard to get one end to the other. And I take that. I think that is an important part of the discussion. Sadly, there's been almost no scholarly attention to this idea of the deep state and bureaucratic resistance. Jennifer and Owen and I did a University of Chicago Law Review podcast a few years back on this, and I mean, there's just been nothing on it. I think that is a serious issue. We have to figure out how serious is it actually? Is it actually leading to delays that get in the way of presidential priorities? I'm somewhat skeptical in most circumstances that the costs outweigh the benefits there. But yeah, I think that is something we do have to look at, is that kind of bureaucratic resistance and how that might cause problems for presidential administration.
Okay. We have a question back there in the corner. Did you, sir? But can I ask you, do you think that and I hate calling them the bureaucrats because it sounds somewhat pejorative, perhaps, I don't know, for some, but do they not have political will? You know, we talk about judges, they were not supposed to have will, you know, they only have judgment, but then we talk about willful judges in this regime. Yeah. Do the bureaucrats themselves not have political will? You're talking about their boss being the one who has the nefarious political will that's against the true thing. Couldn't the bureaucrats have will too, and we just never would know that?
Yeah, I mean, I think that's why it's so important when it comes to administrative law judges and other agency adjudicators that they're selected based on merit and not on politics. And I think Lucia versus SEC that recognized them as inferior officers that had to be appointed by an agency head as a policy matter causes a lot of problems. But yeah, I mean, if we're legal realists on this, I mean, you decide to become, actually, I've interviewed thousands of agency adjudicators over the last decade, and I have to say most of them are very risk-averse legal nerds. It's the policy folks that tend to have a little more mission drive, but most agency adjudicators, outside of immigration, because they're selected based on politics, okay. Outside immigration, in other contexts like the Patent Trial and Appeal Board or the 5 ALJs at the SEC and JARCAC, interviewed all 5 of them. They're quite nerdy folks that know a ton about financial regulation.
Thanks.
Hi, thank you all. I'm Andrew from NYU, and my question is Chevron deference better than Skidmore deference, and if so, why?
You've got all the jokes about it, so.
Yeah, I got a lot of jokes. I'll briefly, I think I'll just go back to what I was saying before in that weight is case by case. And so Chevron was wrong the day it was decided because of big structural questions. I mean, there's a mismatch. Right now, it's a very strange match of that judges take a super hard look at facts and policy, right? One reason I have concerns about DACA and Regents, though I strongly support the Dreamers. There's a mismatch between the Roberts opinion that I think was unpersuasive on taking a super hard look at policy reasons when the Fifth Circuit had already given an evaluation there on the law, and then we're supposed to give deference on statutory interpretation. That's always been a mismatch. So why is Skidmore better? It's because it, first of all, requires agencies to be persuasive. And then if they are persuasive, you can give weight, but weight is very much more of a factor and case by case, as opposed to deference as a rule that doesn't comport with the separation of powers.
Okay, thank you. Did you have a question still? Okay.
Hi, I'm Brian from UCLA. I guess my question, from what I understand, major questions cover things that have big economic or political impacts, and I guess economic, we can put a number on that, but how do we gauge whether something is politically impactful enough to fall under the purview of the doctrine and prevent it from becoming sort of overexpansive?
So I'm glad to have some welcome to the Big Ten. Kind of weird, but hey, we've got it now. I think on the major questions, I actually think the court's moving away from economic impact and more towards politics or more towards, and I think that's a good thing, even though it's less measurable, because there are places where agencies make a rule that's going to have it's going to cost a ton of money and have a ton of benefits. Might be net benefit. I just think it's dangerous to kind of try to put a number on it. I do think the court's doing a much better job, and it's going to continue to flesh out this idea of when is it something that we just think Congress should answer? Has there been legislation introduced? Have they refused to legislate? And I think that's an area, I know some think that this is just like a free-for-all, but no, I think as the court goes through these cases and provides more guidance, this is the type of judgment that courts have been doing for a long time. when it comes to big questions, and I think they'll just continue to kind of refine that. But I don't like the idea of, oh, it cost $1 billion, or like, or you know, because I just don't think that captures well whether it actually is a major question. Major questions are much more, are they fundamentally changing a regulatory scheme, regulating an industry in a way that's never done before, in ways that Congress just wouldn't have provided for. So I don't know if others have different thoughts on that, but that's my kind of gut reaction.
Well, I mean, I think you might try to, and this is just what we do as lawyers, right, is you might try to reason from other standards. So there's the important subject standard that in some ways has suffused the non-delegation doctrine. I want to say it's from Wayman v. Southard. So you might look to that. You might look to the economic significance, not as, you know, economics qua economics, but as a way of gauging, well, how important is this thing to the economy? You mentioned a regulated industry. If we're talking about a regulated industry that's turning over trillions of dollars a year, and this thing is going to have a profound change, it may be politically significant because it's economically significant.
Exactly, yeah.
You know, you said political or economic significance. I'm not sure if it's or and. I suppose I'm still trying to figure out, you know, whether economic has to get in there, or are we going to see the major questions doctrine deployed in cases that don't have much tangible economic impact, but turn on profound moral questions? And did Congress really mean to delegate to the executive branch, say to HHS, to make a decision on a profound moral issue? I don't know the answer to that. But look, this is case-by-case adjudication, and the best that the courts can do is look to standards that they've used in other, maybe you'd call them adjacent areas, and do your best to reason from there.
Speaking of delegation, Professor Mortenson, did you have something to add?
Yeah, just very briefly, I think, about the big picture delegation debate and the sort of kind attention to the work that my colleague Nick Bagley and I did yesterday by Professor Sunstein and Judge Kethledge. It does seem worth saying something about the very big picture framing or posture that gets me, and I know also from my co-author, but gets me to where I landed on the non-delegation question. And one of the things I want to start off with is by saying that the examples in the paper are in some ways the least important thing. There are, in fact, examples across an array of instances of massive delegations that involved potentially criminal consequences. There's stuff that's not in the paper, they're everywhere. The most important thing for us about the examples is not whether they 100% replicate exactly the structure of present-day delegations, but did they prompt a conversation about a doctrine that was allegedly present as a thing that existed in the way people thought about the world. And to me, the most important thing isn't, can you explain why total delegation to the territories, or total delegation to Washington, D.C., or total delegation from Parliament to the Mayor of London to regulate all economics within London, can you explain why those are different? You can, but like the way ideas work is that if there is a school of thought that's available in a serious way in an intellectual community, if the argument's there, and if there's at least some political reasons to raise it, it's going to get raised. And, you know, the silence of the non-barking dog, that argument doesn't always work. But to me, the most important thing about the examples isn't, oh, look, we've shown that the EPA existed at the founding. That's not the claim. I mean, actually, like, the delegations in some cases were way bigger than to the EPA. For me, the really important conceptual work of the paper is part 2, for what it's worth, as you follow along in your own copies, which focuses on the conceptual framework of the separation of powers in the 18th century, 17th to 18th century. It turns out, and this is like the entire super complicated thesis of my book, it's not even a little bit complicated, it's embarrassing, that the executive power just meant the power to execute. Like, that's all it meant. They were not like thinking deep thoughts there, they were just talking about implementation. And because of that, there's lots of entailed implications for thinking about a document that was created vesting powers across 3 branches, and one of them, and to me, like, not even the most interesting one, I hate to say it, it's trivially entailed, is that to talk about the exercise of rulemaking authority as an exercise of, as intrinsically an exercise of legislative power is missing the point when the question is whether the person doing it was delegated that authority by an authoritative decision maker to execute on their behalf. Like, what do we think legislators are? They are the recipients conceptually of delegated authority. There's more to say there, but I would just urge folks who are interested in the debate to focus as much, at least, on part 2, which I think is denser and thicker, and people maybe go a little faster through it, to kind of understand why the silence in the examples in part 3 is so significant. And I want to say, I actually have come to understand and get the instinct for non-delegation doctrine. Like, I get it. I absolutely get it, right? Like, we separated powers. What do you mean you can just redelegate the powers to the executive? That seems like a bad idea. Sure, at the back end you can withdraw them, but we know the president has a veto. Like, I get that. And by the way, also, I'm personally sympathetic to the idea that there should be some limitations on restrictions. But do you know what else I get? I get the idea that the word liberty or the word equal protection of the laws plausibly protects the right to procure an abortion. I get that too. I think that argument writes just as well as the argument that separated powers means you can't delegate them. I understand both. I understand both moves. I understand the appeal to values in each. And I feel like the thing that I've learned from you all, and really I suppose your predecessors, because most of you guys are so young, is a very different posture than I came to law school with, which is like, I can write that brief saying that actually, if you classify on the basis of wealth, that's so problematic given the class dimensions and like the real challenges in our society that we have to give it some extra scrutiny. I can write that, but if I don't have a really good basis in precedent that says it and things like it over and over again that's evolved over time in like a step-by-step testing the trial out system, or in some like deeply embedded political practice, and especially if my claim is running up against deeply embedded political practice, like I ought to, coming back to the humility idea that I think multiple people here have talked about, including Judge Kethledge last night, if I am a judge, which I'm not and never will be, I ought to hesitate 1, 2, 3, a million times before my great smart brain that sees better than anybody else, because I'm so smart and everyone tells me I'm smart, and boy am I smart, thinks twice about how the government should be structured. Like, man, what are you doing? Is kind of my instinct about old me saying, work your way from the Equal Protection Clause to arguing that obviously wealth classifications are suspect. Like, come on, no, Julian, that's like way too ambitious and aggressive and lots of reasons to think it wasn't. It's that instinct more than any other that for me drives like actually a little bit of a passionate disappointment, if such a thing exists, that the set point among the folks the groups that believe in the non-delegation doctrine is like, oh, of course there's a non-delegation doctrine. There literally isn't. There literally never has been. There's 2 cases. The whole government is structured so as not to have a non-delegation doctrine. And by the way, there's no evidence of anybody even thinking about it until like 5 years into the founding. And on that background, the fact that I can write a really good separation of powers essay about how bad consolidating powers is, like that, it's not judicial humility to write that essay and strike down structures of government. And I feel like I learned that from you guys, and that's the disappointment part. Is like that idea that like, and I hope it was being sarcastic on my big smart brain. Like that's the Burkean insight. The Burkean insight is, the wisdom. I should stop. The wisdom of society and of generations and of lots of people working on a problem that's really complicated over time so vastly exceeds our teeny little pea brains' ability to think things through better than everybody else. Like, pause 2, 3, 4, 17 times before you say, oh, looks like the legislative power means the power to make laws. You can't delegate that. Like, no, that's just like, there's other ways to see about it. That's not what Judge Kethledge said. That was not Judge Ketledge's voice. That was, I really mean it. That was not.
This is very good lesson in humility for us all. Because we were at the student event, we were going to give a student the last word with the question and a very quick answer because our time is low.
Sorry.
Okay, I'll be quick.
But that's very important for us all to keep in mind.
I'm Jay from Texas Law. Earlier, Professor Walker made a point about how we live in the era of presidentialism and increasing presidential power. So my quick question is, with rising presidential power, rising administrative state, what effect do you guys think that has had on polarization in America, and what effect do you think overturning Chevron might have on polarization in America?
I think the rise of presidentialism, it's hard to make the causal connect. I mean, it could be the other way around, right? That we have a rise in presidentialism because we have a rise in polarization. I don't think getting rid of Chevron is going to move the needle at all on that, one way or the other.
Can I just make, in this audience, I want to make a special appeal. My understanding of the Federal Society is a distrust of centralized power. My understanding of the Federal Society is the importance of having historical evidence, and my understanding of the Federal Society is a commitment to the separation of powers and checks and balances. I am still trying to understand why there, and earlier today, there was a question, someone mentioned the articles of faith. I call the unitary executive an Article 2 of faith. I'm trying to ask why there is this commitment to this unitary executive theory into presidential power, because when your side is in power, that's great, but when the devil turns, if you've seen the movie A Man for All Seasons, when the devil turns, will the Constitution protect you? I am worried about presidents from either party. And that's why I wrote the Biden versus Nebraska brief. I'm just encouraging the Federal Society members to look at the historical evidence with an open mind.
Well, thank you all to our speakers and our students.